Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani. Once again, my partner David Nachman is still on a vacation traveling, so he couldn't be here today. But we have with us my other partner, Lutka Zimocek. She's also an attorney, part of the NPZ law group, and I requested Lutka. She said she's more than happy to speak with our ITV and Vision Avesha viewers today. So welcome, and she has many years of experience and a lot of things she knows that she can share with on this program today.
Namaste.
Thank you. Now, by the way, thank you very much for the namaste to you also. I hope that in the coming months you learn some more Hindi and Gujarati and you can talk with our viewers in those languages.
I hope so. I certainly hope so.
Okay. Now, before we start the program today, there are a couple of announcements that I want to make. One of the things which is very interesting is that I had an occasion to meet Congressman Caroline Maloney of New York, and she told me about this campaign that has been going on to get approval of the Congress or a particular committee which is responsible for this to issue a Diwali stamp, which will be a wonderful thing for the first time. Recognizing Diwali as a festival will be a wonderful thing. And I must also acknowledge, I think, Attorney Ravi Batra and Ranju Batra, both of them have been working very hard. I think they have collected maybe thousands of signatures and a petition. So we thank them also. But you should also, it's a good idea if you can write a letter or contact your congressman and support this cause, and hopefully by this Diwali we may have a Diwali stamp. Isn't that wonderful, Lutka?
Definitely, that's a good idea.
Okay. Another announcement is that every year TNAC International Film Festival in TNAC has a 2 or 3 days of festival in which they show some documentaries which are very interesting. Some of them really relate to the conditions of the people, the issues that generally are not shown in the regular feature films. They also show feature films, and very interesting for you to understand or learn or to know this. This year, that's about November, I think, 16th or 17th, and we'll give you the exact date and the auditorium in our coming programs. They have agreed to show a wonderful movie, English Winglish. And I think our law firm did the visa work for them. So that will be very interesting. And if you are interested, you can go on the TNAC International Film Festival website and get all the information. And we welcome you, your friends, your family, bring them, see the movie, meet the people, and you'll find that 3 days program actually. You'll be seeing a lot of other documentaries and movies. It is in TNAC, New Jersey. Okay, the third announcement is not an announcement, but a piece of very important information is about the family second preference category, which is becoming current, and by the time you are watching the program, probably it will be the month of August, I believe, and the entire month of August you can file I-130 and a 485 application for adjustment of status of your spouse if you are a green card holder and your spouse is in a valid legal status. That's a very good option. You want to say a few words?
That's very important.
You want to say a few words about that?
Yes,
What's the
yes.
importance?
I just want to say that we do get many calls, and I want to emphasize that the applicant absolutely has to be in current legal status. That means that if you're in F status, you need to have valid I-20. It's not enough that you entered with the F status and you don't go to school. It's very important that you have valid status, whether it's H-1B, whether it's F1, whether it's E-2 visa, just valid status. That's very important, actually.
Okay. Now, let's start with the core of the program today. Is a question that often comes when a person's visa is denied. It's denied because there are almost 32, 33 grounds of exclusion, what we call, in the immigration law. And if somebody falls in any of those categories, the American consul will say, I am denying your visa because of this reason. A very common thing generally is a fraud or misrepresentation. People that might have committed fraud or made a wrong statement or lied in order to get a visa for which he was not eligible, and the American consul is looking very closely any previous visa applications, any record with the immigration service, any record with the CBP at the time of interview. Anywhere he finds that this person made a false representation, he will deny under section 6C. Do you know what is the penalty for that? 6C denial is a lifetime bar. For the rest of your life, that person cannot get any kind of visa for the United States. And first of all, we must say that please do not do any of those, not a good idea, because there are serious problems, consequences, and sometimes you may not even get a waiver. So don't do it. But if somebody has done it, what is the option? Some of the options that are available for some of the categories is called a waiver. Hindi mein bolo to maafinama samajh lo. So basically for that I'm going to have Lutka to explain you first of all provisional waivers, and that I believe is only available for the 9B, which means the 10-year or 3-year bar coming from unlawful presence. So explain to our viewers.
Exactly. That's very important to know that provisional waivers are available only for unlawful presence in admissibility. So it does not apply to fraud, as you just mentioned, definitely does not apply. That would be a regular waiver. So let's discuss provisional waiver. Provisional waiver was implemented on March 4th, 2013, so it's pretty new. It can be filed in the United States, but very important, the person has to have a qualifying relative, which is either a US citizen parent or spouse and not a child. That's common mistake.
You know, used to be, by the way, Lutka,
yes,
it used to be many years ago, I've been practicing 40 years, child was included. And the law changed, I think, 96 or so, and they took away the child. And once again, the comprehensive immigration reform bill that we are talking about, that is there.
And
so
it should be.
It should
be.
It
definitely should
and
be.
if that gets passed by the Congress,
yes,
then that. But right now we are talking about today. Now, again, let me just clarify a little bit. Let us say that there is a person here who came illegally, right? And he gets married to a US citizen, and he's not eligible for section 245I, which means having filed the petition before April 2001. I have people, you have people, you know, a lot of clients, a lot of people waiting,
yes,
and they say, I'm married to a US citizen, why can I not apply for a green card? You can apply for a green card, but you cannot adjust the status. In the past, those people that were eligible for a waiver, and waiver is based upon extreme hardship, obviously, they had to go to India, Pakistan, wherever, and apply there. And the consul will then deny and put them in a bar. And they will apply for a waiver, but until the waiver was granted, they will be stuck back home for years. And the waiver applications at those periods were decided by the Overseas Immigration Office, mostly the USCIS office in New Delhi, which has a jurisdiction over India, Nepal, and neighboring countries. Now, this provisional waiver that Lutka is going to further explain to you changed the whole situation. I believe now that person who cannot adjust still can apply. Like the wife citizen files for him, and petition is approved, and he goes back to the home country to apply. But the change is that now provisional waiver says you can get that waiver approved right in the US rather than being stuck back home.
It's definitely much better for people. It helps family unity because it was very risky for people to leave the United States, go to their home country, wait for a waiver approval, and then, as you said, if it's denied, then the person would be stuck outside of the United States.
So I have one more question on that. So you, Lutka Zimochek, a good immigration lawyer, gets the approval of the provisional. What you're going to do is to file an application here, show them that there are qualifying relatives, and show them extreme hardship also. That's one of the requirements. And that gets approved. Thank you very much. Club goes to India. He is looking at other issues as well. How did you go to US? Through the agent, cross the border, whatever. So the consul is trying to find out, can I charge this person for fraud, misrepresentation? And if he has a good basis and he does that,
they certainly
then what
can.
happens? Then that's the question. Then what happens?
They certainly can, and I'm very careful about this issue, so I do go through the history of clients' immigration history to make sure there is nothing, because that could certainly happen they go for the interview, they're all happy because they have waiver approved, they're happy to come back to the US, and suddenly they're going to be stuck because the officer could find a different ground of inadmissibility. Let's say they committed a crime they forgot to mention to me,
Yes.
or they committed a fraud 20 years ago that they forgot to mention
Or
to
a
me.
prior deportation.
Or prior deportation. That's a good one. So I'm very careful, and it's important for all attorneys to check the history of the clients. Crimes especially, because if the crimes were expunged, clients forget to mention to
I know,
us.
Lutka, you said important for attorneys. Unfortunately, our brethren, there are many lawyers who don't think of that. Oh,
Yeah.
provisional waiver is there, I'll get you a waiver, you go and get a visa in India. Come on, I mean, basically you are putting in this guy in the lion's mouth.
Yes.
So this is very, very important thing that you must consult an experienced immigration attorney to make sure if you take that step, be prepared that if the council may charge you fraud, you may be stuck for a long, long time.
Yeah. And also be honest with your attorney. That's very important. So you have to tell us everything. All the fraud you committed, you might have committed in the past, or you think you committed, all the crimes.
Yeah. And this provisional waiver is only for the bars, 9B,
Yes.
not for a fraud or misrepresentation. So what happens in the case where a person, you got him a provisional waiver, he got stuck, and the council has charged him with a 6C fraud misrepresentation. Now that also, the waiver application can be filed or has to be filed in the US only. So
That's
we are out
correct.
of the problem that in New Delhi, what they may do, or Bangkok, what they may do. We are out of that. So question to you is, so client comes to you, your client is stuck there and you have to file a 601. What will you do in that? What are you looking at his qualifying? What are you looking in terms of evidence, documents? How can you satisfy the immigration service about getting the waiver approved?
Okay, so if the provisional waiver is approved and the consulate will find my client ineligible under a different ground, then I'm going to refile the waiver.
Again,
The good news is that it's the same extreme hardship. So if the provisional waiver was approved, the chances are that this new waiver is going to be approved, but unfortunately the client will have to wait for the new approval, and that could be several months.
Right.
So
and you're looking at what kind of documentation in order to prove the extreme hardship. What do you generally?
So the government looks at different factors. They do look at education of the petitioner. They look at the medical history. That's very important. If there are any issues, they do look at the country conditions.
Yeah.
They do look at
Depression.
employment.
Some people get depressed.
Yes, that's
and
part of the medical
record. There are physically other problems. Parents are living in India. They're elderly and nobody take care of them. Family ties.
Family ties, very important. And I want to point out that we discussed that child is not a qualifying relative. But if child is sick and the U.S. citizen spouse absolutely has to take care of the sick child, then it's important.
It's an indirect way
Yes.
of like
Exactly.
Listen, like that wife is here, and she's got 2 children. They're going to school, and she's also working. Extreme hardship is there.
Yes.
She's got to take care of. Sometimes she's taking care of the in-laws. Sometimes she's taking care of the little children. There are so many different angles, so many different things. It has to be fully documented. One thing I've been telling in the TV, all of our viewers, prepare the documents and a waiver application so strongly that when that immigration officer is looking, he has a tear in his own eye. Oh my God, this
That's
really deserves it, and then your application is approved. And then there are waivers also for other things, for a crime, sometimes for a person is convicted of something. HIV ground is no more there because the law changed and HIV is no longer a problem. But it's very complicated, it's very important, it is something that you don't just do yourself. It's very difficult for you to prepare a waiver application and file.
Yes.
Must consult an experienced lawyer, not just any lawyers. There are a lot of lawyers, unfortunately, our burden, we say they don't fill up a form and just mail it. I mean, we believe it. I saw a case, we filled the form and sent a check with it.
Yes,
So-
and if you do that and the case is denied, then our work is more difficult because we have to fix whatever was denied.
Thank you very much for being with us today, and thank all of you for watching the program. please keep watching us every Saturday and Sunday only on ITV and Vision of Asia. Thank you very much and goodbye. Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my partner Lutka Zimochek. Again, you might have seen her in the last program. Lutka, welcome.
Namaste.
Very good, very good. Your namaste will make them very happy that Lutka Zimochek is doing them namaste. Okay, a couple of announcements that we want to repeat that we said last time, very important, that I did meet Congressman Caroline Maloney. She's a congressman from New York, and she has been pushing very hard to get approval of a Diwali stamp. There's actually an organization which is called Citizens Stamp Advisory Committee of the Postal Service. But congressmen play a lot of role in that. So that one thing that I want to request you, appeal to you, that you should contact your, you want the Diwali stamp, I'm saying. You should contact your congressman and push for this, and hopefully by this Diwali we may have a Diwali stamp. So that may be a very good thing to happen. The other thing is that the TNEC International Film Festival every year has the TNEC Film Festival in the month of November. I think it's going to be around 16th or 17th of November, at which time they will be showing a lot of documentaries on various subjects, some feature films and movies, and there will be some directors and people coming on the program and explaining about how the movie was made, and there will be some of the programs of refreshments also maybe. So it will be a very good idea, because this time they are going to be showing English. Remember Sri Devi and Bonnie Kapoor's wife, and she was the main heroine in that. So it will be very interesting. By the way, we did the visa work for that movie. So
Yes.
that will be interesting. You should also come, Lutka, for the TNEC festival.
Definitely.
Okay, now let's also talk about, we are still probably in the month of August now, today, when we are giving this program. So remind them about the F2A category having become current now. What are the benefits some people, we did talk about the last program, but we did not talk about the people who are waiting abroad for visa processing. So tell our viewers about, if a green card holder is married to somebody who is in a legal status, that can be done right here. I mean, you can file I-130/45 here in the month of August. Hopefully within the 2 or 3 months, if the visa number is still current, they can get the green card here. But if the person is waiting in India, the wife is in India, husband is here, then what are the different steps, and under what circumstances would you say this will benefit that person?
It's a little bit different if the beneficiary is abroad in India, because we first need to file the petition, I-130 petition, and that takes about 5 months to process. Once it's approved, then it goes through the national visa processing, and at that time we have to look at the visa bulletin. Hopefully it's still current, and then the person can go for the interview and get the immigrant visa and come here. But at the time, we need to look at the visa bulletin. We don't know whether it's going to be still current or it's going to retrogress again. The government is stating that probably it will only take few months, and then it's going to retrogress again.
Very good. So what I'm also explaining to those clients and people that have this question, people who are the spouses and back home in India or Pakistan, Bangladesh, any place, what I'm saying that, listen, understand there are basically 3 major steps of the process. Step number one is the green card holder has filed a petition with the immigration service here. The petition then gets approved and goes to a national visa center, where they will collect all the documents and birth certificates and marriage certificates and police certificates and the affidavit or the whole 9 yards there. Once that is all complete, and then they keep the case pending, this kind of case, until the visa number becomes available. So people that went through the process, they got the petition approved, they already got the NVC processing completed, and just waiting, all of a sudden they should realize visa number has become available in the month of August. So if you should push your lawyer and tell them to contact the NVC immediately, try to schedule the interview. Even I hope that this will at least be 2-3 months more, that the numbers may remain current, and then the council can complete the processing and issue the green card, the immigrant visa.
Certainly. For those cases that are already approved and are currently at the NVC, it's very important that it's scheduled now while it's still current. That's very important.
Now, let's go back for a minute for those who apply for adjustment of status. Now, people say, what happens if the 2 months, 3 months down the road, case is still pending and the visa numbers retrogress? That may take few more months, maybe, or a year or
even
more.
years.
But there's a big benefit is still coming. That spouse who's a student or H4 or whatever legal status will get a permission to work within 90 days. Will get also a permission to travel within 90 days. So what? That you can work and live here illegally and go back home also.
That's very important.
The only thing is the green card is delayed by a few months, so what's the big deal? And in between he becomes a citizen, then that can be completed immediately. That pending case under 2A, sorry. Right?
Yes, that's correct.
Okay, now let's talk about a different subject, which is like this. People ask that you have been telling that the new law, the Comprehensive Immigration Reform Bill, has been passed by the Senate. So when is that a law? When can that become a law? Is the bill going to pass in the House or not? It's difficult to say. I mean, I'm very hopeful, and Lutka is probably hopeful, maybe not to the extent that I am. I think there's a lot of pressure on the Republican Party, who lost that election, and Obama won that presidency. Romney lost it. They realize that there are millions of people living in this country, and they will continue. If they don't pass the law, what will happen? There's a lot of pressure coming from the employment groups, from the big companies that are contributors, and people want the STEM Act. People want those people who are working here, H1, L1 visas. They want them to get a green card. So a lot of pressure coming from all different skilled workers, the agriculture workers, and even there's a big division in the House itself between the Republican Party. Some people want it because they see that their counterparts in the Senate with a majority of about 68 votes pass the bill. So that's a lot of pressure. I'm hoping that the bill will pass, and then a lot of benefits will come out of that. We don't want to go into that, because if we go into that, then I cannot talk about rest of the stuff. So the question here is, what if the bill does not pass? Because we have said the bill passes, all these categories, the waiting lines will move very faster. So they will remain in the same situation. So let us go one by one category. Let us start with a family cases first. People are waiting in lines. And let us start about the employment cases also, where people are waiting in long lines. The family A category, the first preference, IR people, immediate relatives, which means the spouse of a US citizen, parent of a US citizen, child under 21 of a US citizen. They don't have to worry about this.
There is no line.
No line, there's no quota, in other words. Non-quota case, they understand better that.
Yeah.
So let us talk about a family first preference, which are the unmarried sons and daughters of US citizens. Presently, the cutoff date is
it's
2006.
Yes, 2006.
Now that means they may still have to be another 6 years, 7 years.
That's correct.
So now what shall we do? The guy is coming to you, say, Lutka, please help me. 6 years I have to wait. And in that 6-year period, if he gets married, then he goes even more years behind. So what are the kind of options? And you tell them what can they do. What can they do? They can look at the other options.
Obviously, we have to look at the resume. So I would request that a person brings a very detailed resume.
So what you are looking at, okay, in the meantime, how can they at least come here on a temporary visas and also work? So then, that's okay, go ahead.
I do look at the non-immigrant options with the dual intent. So for example, H1B or L1, if they do have a good credentials, O1.
It's possible then, because the council cannot deny. The important thing, dual intention, you say.
That's what I mentioned, dual intent.
Yeah, intent means that even if somebody is married to a citizen, green card holder, even if the petition has been filed and council knows that he's an intending immigrant, the law says he shouldn't look at that, and he should process the H or the L categories at least. So this client is coming. So what are you looking at him? You're just in your mind thinking, does he qualify for H1? Does he qualify for L1? Does he qualify for O1? What are you looking into him? And what are you telling him what you need to do is H1 or what you need to do is L1?
Well, it all depends. If the person works for the company that has a subsidiary or parent company in the US, then I would be looking at the L1 or L1B visa, certainly.
Yeah.
If we are, let's say, in March or we are in winter and April is approaching, then I might be looking at the H1B. And specifically, if they tell me that they do have somebody who would be willing to petition for them, and obviously they need to have a bachelor's degree because it has to be professional.
And the job has to be in the same field of his education and
Yes,
experience. Right?
very, very important. So I do go one by one and I do review resume. Some people might publish. Some people could have 30 publications, or they are artists. So maybe O1 would be an option. So it just all depends, but it's very important that I speak to clients and I do ask all the right questions.
But even that's good. That's a good. I mean, basically, we always look at possibilities of H1, L1, and then we have to tell them the requirements that we need education evaluation. Sometimes because somebody comes and he says, "I have got a degree, but it's not equivalent to the U.S. college degree. That's a requirement of your H1B." So you and me will look at the experience. Sometimes there's only 1 year difference is there between the US degree and the Indian degree, which is very common. We look at the experience of the person in a professional kind of work. And the rule of the thumb is that 3 years of experience is equivalent to 1 year of college. Like I say,
Yes.
you have a glass of juice, it's still not completely full, this much gap is there. So you go to another place from which you get that same juice, not a different juice, same orange juice to orange juice, put that in the glass and complete the glass of the juice water. That is called equivalency based upon combination of education and
Yes.
experience.
So
People forget that all the time.
And you need about 12 years, basically 12 years of experience for...
No, 3 years experience. Let us say they have a college degree.
Yes. But, if
But
they
that's
don't
only
have,
missing 1 year.
Yeah, definitely.
So the person has 4 or 5 years experience and
Yes.
we can then do that.
But if they do not have any type of college, then it's 12 years of experience.
No, you're talking about temporary visa. Very good
Yeah.
information for our people.
Yes.
But let us say that I'm looking at green card some other way. Green card on this other way. How about an EB2?
That's a good one. Are we still talking about the family cases though?
No, employment. You go into employment. We can.
It
Okay, by
happens.
the way, that people say, oh, but I'm already in the line. How can I file another petition? That's the wrong
That's
thing.
very common. That's very common.
But there's no limit on the number of petitions, number of lines you can be standing in. So
Yeah.
what will you say if the person is educated, master's degree, PhD, smart, you got a good job? I will recommend and you will recommending if you have an employer in the US who will file a labor certification for you and you can come under the EB2 category. Which is interesting thing, Lutka, is that if the person is born, wife here is unmarried, remember. If the
Yes.
person is born in a different country other than India, then that category is current for EB2.
That's called rule of cross-chargeability, and we use it very often, and I have to say that many people forget. So that's very important to check and ask the question, are you married, and where was
No,
your
but in
wife?
this case, a EB is a F1, that's unmarried son or daughter.
Oh, okay.
So therefore, we are looking at him in terms of EB2. Okay, also if he says, I cannot wait, especially in the case of girls, the parent says, I cannot keep my daughter unmarried for another 7 years, what shall I do? If it's a F1 category, I tell them, okay, go ahead, get him married, doesn't matter. It's not go away, this petition will continue under a different category called family third preference,
Yes.
which are the married sons and daughters of US citizens. The waiting time will increase substantially, but it's okay. I mean, their husband is there, children can keep on, bringing the children up. And whenever, even if it takes 10 years, when the number comes, she gets immigrant visa, husband gets it, children comes in, whole family comes in. So this is one of the options that I always give them, that if you cannot wait, go ahead, change the category, we'll still bring them here when the visa numbers for the F3 category becomes available.
But that's where it's important to use a rule of cross-chargeability.
Correct.
Because one of the spouses, let's say the husband...
The F3 you are saying.
Exactly, in a F3,
Ah,
maybe was born in Bangladesh.
Correct.
Or in a different country where
But F3 is that there's no difference, but EB2 is the
yeah,
difference.
EB2,
Yeah, EB2.
exactly.
Yeah. Well, Lutka, as usual, looks like we are running out of time, and I thank you very much for giving some good information to our viewers, and welcome you on this program. Hopefully, we can continue to bring you back again on the next program as well. So, thank you, viewers, for watching our program. Please keep watching us on ITV and Vision of Asia every Saturday and Sunday. Thank you very much and goodbye.